All right, folks. So continuing with chapter 14, we just discussed general tenancies, mostly for commercial lease. Now we talk about the residential tenancies. So the residential tenancies, they are more protected. Actually, tenants are more protected because legislation considers tenants to be the weakest party in a renting agreement. So there's provincial legislation for residential tenancies, and also if you just Google rent BC, you will find the provincial government website in which where you can find standard form leases. You can also find forms for inspections, forms for notices, and a lot of educational materials in regards to residential tenancies. Differently from commercial tenancies, the landlord does have a general obligation to repair and to the quality of the facilities. So let's say your heating is not working, the landlord has to fix it, or the fridge has some issues. It is all under the duty and obligation of the landlord. There's also a need for notice of termination. So it's usually 30-day notice before you can move out, or the landlord wants you to move out. In terms of security deposits, so I learned this myself. When I first moved to Canada, I was requested to pay 3-month rental deposit, and then I just counteroffered to make 1. But after I moved and being here in Canada, I found out that legislation limits the security deposit to half a month rent. So being a lawyer, after I found this out, what do you think I did? Actually, I did nothing. I just let my landlord to keep my 1-month deposit, and then I terminated the agreement. After 1 year, I moved to another place, but then I had learned a lesson, so I never paid more than half a month deposit after that. And again, the landlord in a commercial rent or commercial lease has the right of distress, in other words, to seize the tenant's property for undue rent, for example, but this right is not available for the landlord in a residential tenancy. Now we look at personal property. So we discussed a lot about real property. Now we look at personal property. So as I said in the beginning, personal property, they can be chattels, or in other words, goods. Chattels, the legal term, and those are multiple things. Examples there: electronic devices, clothing, even animals, motor vehicles. They are all regarded as chattels or goods as per the law. Fixtures, they are a chattel when they are attached to the land. If they are permanently attached, then the fixture become a real property. If it's not permanently attached to the land, the fixture, even though it is attached, but not in a permanent way, it is still a chattel or a fixture, not real property. The trade fixtures, such as company sign, for example, they are known as not being incorporated in the building. So whenever you rent and you have a trade fixture, you are allowed to take it out after you move the property. Finders keepers. So this is interesting law about finders. So let's say you found a valuable item, a valuable chattel on the streets, and who can keep it? Can you keep it? Do you have to return it? So the law says the only person that has a better claim other than you in the property you found, in the chattel or goods you found, is the original owner. But you, the finder, you don't have a duty to look for the owner. just in case the original owner finds you, then they will have a better claim than you have. If you find something in a public place, you can keep it to you, as long as the original owner does not claim it. And if you find it in a private space, let's say you found something here at BCAT, so the owner of the place owns it. If you find something at a restaurant, the owner of the restaurant owns it or may keep it. So here at BCAT, for example, when you find something that doesn't belong to you, you should return it to the security office. And the obligation to return, it is only there when it's possible to do so. But in most circumstances, we just cannot find the person who left something to fall, except when our chattels that can give us a clue on identification, such as, for example, sometimes smartphones or wallets, we could identify that. Now look at this question. I'll give you 1 minute to look at this question. Okay, so I actually changed my mind, and you can pause this question so that you find the right answer. The right answer would be C, which is when a person finds a valuable watch in a public place, they are entitled to that property over everyone else except the rightful owner. Moving on, we have bailment, and bailment is when someone, the bailee, acquires the temporary possession of personal property owned by another, and this another is known as bailor. The best and good example in here would be borrowing a book from the library. So the library would be the bailor, and you, the bailee, you are acquiring temporary possession of that book, and you have to return it after or when time is due. Bailees, they are liable for damage to the goods when the goods are in their possession. So you borrow this book from the library, and then you just spilled coffee on it, you cause damage, then you are liable to this. We have some other types of bailment, and we'll look into them now. So there's bailment for value. It means both the bailor, the owner of the goods, and the bailee, the one keeping the temporary possession of the goods, they have a benefit, so mutual benefit. Example is when goods are being repaired or stored or transported. So if you send your smartphone for repair, it means the bailee, the shop, fixing shop or the repair shop, they will have the benefit of your payment, and you will have the benefit of getting the goods repaired. So that's the bailment for value, one example. In commercial relations, as this one, the level of care will be the one that is expected in that industry, or the one that is stated in a contract. So we should expect that the level of care is a little bit higher. He's not just a reasonable person, but is a reasonable person in that industry. So how do repair shops take care or good care of smartphones when they are there to be repaired or fixed? So this would be the level of care in regards to your goods. For common carriers, such as trucking companies, airlines, or even railroad, they have a higher standard of care, because actually their main service is to transport your goods from point A to point B. Thus, they are being paid for that, so it's also a bailment for value, and they are liable. Their standard of care is similar to an insurer, which means they are liable for damage even if the damage was not caused by negligence. So let's say they had a duty of care, they did not breach this duty, there's a damage and causation to it, but they didn't breach the duty, they are still liable on that. Why? Because the legislation says their standard of care is the one comparable to an insurer. Okay. For innkeepers, things changed a bit, and innkeepers, like manager of restaurants, hotels, they are liable only when they are at fault. So you left something at a restaurant or at a hotel, and only if there was negligence, and then this negligence caused the damage to your goods, then they will be liable. The gratuitous bailment is when only one party receives a benefit. So only the bailor, the owner of the goods, receives a benefit, or only the bailee, the one having the temporary possession, receives a benefit. So if it's for a benefit for the bailee, for example, when I borrow your car, when I borrow your lawnmower, so you are the owner, you are the bailor, and I am getting this temporary possession, I'm borrowing your goods, I'm the bailee. In those circumstances, the standard of care with the goods, they are a bit higher and they lay on the bailee. So the bailee is liable for any damages that is caused to the goods that were borrowed. However, when it's for the benefit for the bailor, and the example here, so I'm the owner of the car, I'm the bailor, and I ask you a favor. Can you store my car because I'm going to go to Brazil for a month? Can you keep it in your garage? So you don't have any benefit. You're just doing a favor to me. So I'm the bailor, the owner of the goods. I am the only one having the benefit in here. In this case, the liability for the bailee, the one having the temporary position, your friend doing a favor to you, will be only originated if there was gross negligence. So let's say you are storing my car for me during my trip to Brazil, and if you keep my car parked on the streets in front of your house and it's locked, all windows up, I don't see any liability on you if any damages are caused to my car. But a gross negligence would be, let's say, you left my car unlocked, windows down, so it is gross negligence on your part. In this case, you would be liable, even though you didn't have any benefit, you just did a favor to me. Involuntary bailment is when we forget our goods. So we are the owner of the goods, we are the bailor, and we forget our coat, for example, in a restaurant. So the restaurant, the bailee, having temporary possession of our coats, they do not have any duty of care until they accept the goods. So we forgot the coat, but the servers are busy serving, and they didn't accept your goods yet. So they have no liability. Once they accept the goods, so before closing the restaurant, or at any time they learn a coat was forgotten there, then they have a duty of care to take good care of your goods, and they also have to return the goods to the bailor when the bailor returns to the place and claims ownership for those goods. Now this other question. So you can note in here that Jane is asking Harry, her friend, for a favor. So her friend is not getting any benefit. This is an example of a gratuitous bailment, and this is for the benefit of the bailor only, the owner of the violin. So the right answer here would be B, letter B. Okay, so just reminding you that protection of the environment is not examinable. It's not going to be in your exam. I just want to drive your attention to the protection of the environment is something very important and very key for the business world, even for our personal lives, because let's say you're planning to build a warehouse, so you go there, buy the land, but you didn't pay attention to the environment protection legislation in that place. And after you purchased, after you made investment, you find out that you cannot have a warehouse built there based on prohibitions of environmental legislation. So this is something we do not discuss in our courses, but it is something you should keep in your mind if you are in business, mainly if you are to start your own business. Do I have, is there any restriction for the business I'm planning in here in this specific location as per the environmental legislation? So that's the question you need to have answered before you make your investments. So that's it. That's the end of chapter 14. Again, I hope this video is of benefit to you, helps you learning and understanding the content, and do not hesitate to reach out to me via email or in person if I can be of any further support to your doubts or questions. Thank you. See you for the next chapter. Bye.